Good afternoon. Hello, everyone. Thank you for joining us today. We are going to speak with you about property law and COVID 19. We hope that you are doing well and you're safe and happy during this uncertain time. Before continuing on, I'd like to thank our friends. All these people, institutions, and companies have promoted our webinar today. And because of this, we have been able to reach out to so many people. So thank you to all of you for promoting our webinar. After this webinar, you will receive an email. The email will contain a question and answer kind of survey, and we ask that you spend a few minutes just to answer it so we can learn what we can do to improve. Uh, we made this webinar engaging. It's customized based on the questions that you provided when you registered, and we like to continue to know what you like and what you don't like so we can provide that to you in the future. To thank you for your time, you will receive a Starbucks gift card or a Walker Law mask. Um, if you receive the gift card, it looks exactly like the gift card on your screen. So please don't throw it away. It's not a business card. Before we continue on, I just wanted to take a moment to let you know that we have partnered up with a charity called Renewed Computer Technology. And what it is a organization where if you have technology that's just laying around the home and you don't need it anymore, children that are in need nowadays to learn from home, who knows when they're going to go back to school, we are collecting this technology and submitting it to Renewed Computer Technology. This is funded by the federal government. So if you have any technology that you just don't need anymore, please contact us at the information below. Also, if you have enjoyed today's webinar, I will suggest that you might want to join us in the future for other webinars. Tomorrow, I will be presenting to the Canadian Bar Association on doing business in Africa. That is only open to lawyers who are members of the Canadian Bar Association or American Bar Association. On July the 9th, we will present on employment law, and on August 6th, we'll provide an update on property law. That information will be sent to you after this webinar. Also, you may want to subscribe to our YouTube channel. Last week, I was on national television, CTV Your Morning, speaking about the possible elimination of jury trials for civil litigation. And so that's something that you may want to keep on top of. So we will provide you a link in that email as well. So the agenda for today is as follows. It's a housekeeping and introduction to our team, update on the government's response to COVID-19 with an emphasis on property law matters, and in property law, an emphasis on commercial lease matters. We will answer your property law questions, commercial leases, frustration of contracts, how power of sales may occur during the pandemic, and how to resolve disputes about the scope of a residential construction project. We will also proceed to answer your questions. But I don't want you to wait till the end of the webinar to ask questions. Ask away. You'll see the chat at the bottom of your screen. And if you click on that and type in your question, we will answer it after each topic is covered. Rishi Nagashar is a lawyer with our office. He will answer your questions in writing, but we will read some of them out depending on how many questions we receive. We have a number of polls to make this webinar as engaging as possible. And what polls are is you vote and on what you believe the correct answer is, and then we will share that with the group. So when that pops up on your screen, that box, click on the answer that you believe is correct, click on submit, and then we'll share the results. So the roadmap for today is as follows. After we provide an update on the law, a poll will come up, and so we can understand your perspective on that issue. We'll discuss the law and the correct answers, and afterwards we will provide to you some suggestions on knowing what you know now, how can you protect yourself going forward. So our objectives for today, we want to help you understand the new ban on commercial evictions. We want you to understand when a contract has been frustrated, determine if a power of sale may occur during this pandemic, and learn how to resolve disputes involving residential construction projects. So a brief introduction, my name is Tanya Walker. I started this firm 10 years ago. I've been practicing for 14 years, and I specialize in property, employment, and contract law. Jordan Routliff is an associate with our firm, and he will be a panelist as well. Our other members of our legal team include another Jordan Koenig, who is specializes in employment law, Marley, who's a paralegal student, and Rishi Nagashar, who's an associate who just became an associate after articling with our firm. Special thank you to Rishi for putting this presentation together and doing all the research that he did. Thank you very much, Rishi. So I'll start off with the first poll. And I want to know what property issues concerns you the most. Commercial leases, residential leases, contracts, power of sale, construction, or other. And if it's other, please let me know by writing what it is in the chat below. While you're voting, I just want you to know that we're also broadcasting this webinar on Facebook Live. Unfortunately, the polls do not show up on Facebook Live, but you'll be able to follow along. So I'll end the poll in about 5 seconds. So most of you are concerned about commercial leases, and it's understandable given that the law just changed last week. Next up is residential, contracts and power of sale are tied, and then construction. So we will make sure that we emphasize most of our time today on leases, commercial and residential. Thank you for voting. So we'll head into part 2 of this webinar, which is the government's response to COVID-19. We presented at the end of April, I believe it was April 24th. And so it's the government's response since then. So looking at the federal government, the federal government has expanded the Canada Business Emergency Account. And what that means is loans of $40,000 were provided from the federal government, and it does not have to be repaid for about a year or two. And when you do repay it, you only have to repay $30,000, $10,000 is a grant. So it was initially for those businesses that had a payroll, but has been expanded to include sole proprietorships and those who pay themselves dividends. Temperature screening is to occur at the airport. So if you have a fever, you may not be able to board your flight. Changes to family laws are delayed. Some family laws were supposed to change effective July 1st this year. That has been postponed to March of next year. The province of Ontario has been very busy and has implemented new laws, but I also want you to keep in mind proposed laws. So our state of emergency has been extended till the end of the month. It may be further extended till July 15th. It has been extended already 3 times. There's an infectious disease emergency leave, and that is more of an employment related matter. What that means is usually when you lay off an employee after a certain number of weeks, I believe around 13 weeks, you are, if you don't recall the employee back, the employee can sue you if you're the employer for constructive dismissal. And so this infectious disease emergency leave has extended that period of time to prevent lawsuits. That will be further elaborated on in our July 9th webinar. Phase 2 of reopening for many parts of the province have started. Today in Toronto, it has started. And there's changes to commercial lease law, which Jordan will discuss shortly because it's quite extensive. There are proposed laws in place. So there is a law regarding residential tenants called renovictions. And renovictions is when the landlord says, I need the premises to renovate or I need the premises to live there. But what it really happens is the premises is renovated and maybe rented out at a higher price to a tenant. And so the proposed law is to punish landlords who use this reason to get the tenant out. And the penalties are going to be severe if this law is passed. The fine could be $50,000 for individuals instead of $25,000 and $250,000 for corporations instead of $100,000. Also, the landlord, even if the moving in is legitimate, the landlord might have to pay up to a year of rent of 30 or 35,000 to the tenant. So you might want to pay attention to that law to see if it passes. Going on to the City of Toronto, there are not many changes in the City of Toronto you probably haven't heard of. The City of Toronto now, effective July 2nd, you have to wear face masks if you use TTC. And because a law hasn't passed regarding rent evictions, there is a website actually active that provides kind of tracking information on certain landlords that have used rent evictions as a reason to renovate the premises and then rent it out to someone else. So changes that have been implemented by the courts, that's the sign for the court, is that now the courts are hearing most matters electronically or in writing. We have argued by video conference and by telephone recently. Courts, depending on the region, so Toronto courts are different from Ottawa, different from Oshawa. They all are they're not necessarily doing the same thing in terms of dealing with matters. So if you have a matter that's in court, you would have to check and see what that specific court is dealing with at this point in time. So small claims court, if both sides agree, the deputy judge will deal with a settlement meeting virtually, but both sides have to agree. And effective in September, the Ottawa courts will schedule all judge trials. They're going to proceed. Limitation periods continue to be suspended. So what that means is if you are sued and you have 20 days to respond, you don't necessarily have 20 days before that person gets judgment. That rule is a little bit different for lawyers because there's the expectation that we will abide by timelines unless there's some extreme reason not to. There's also proposed changes that affect the Ontario courts, which is ending jury trials. That's what I mentioned, I spoke about on TV last week. And also considering preventing lawsuits regarding infections. So what this means is if someone gets COVID-19, they're working for the TTC and gets COVID-19 and they believe that they got it from a coworker, there is a proposed law that they may not be able to sue the TTC. So that's another one to pay attention to because that might come into effect. So Jordan will speak more about the ban on commercial evictions.
Thank you, Tanya. So this is obviously a very hot topic right now. The laws came into force on June 18th, so it's very, very fresh. And there's lots of questions about these laws. So we'll give you a brief overview, give you a little bit of a sense on the key elements and raise some issues that you may want to turn your mind to in dealing with these new laws. So from the top, the central requirement of this new set of laws is that the landlord be eligible for the rent relief program known as CECRA. So what that means is essentially if the landlord is not eligible, it doesn't apply. So you have to look at that gateway criteria first. I'll talk a little bit more about that in a bit. Assuming it does apply, the period in which the ban applies is from May 1st to the end of August. So interesting, it's a very interesting set of laws in that way, in that it's retroactive, and that is going to create a number of problems because what the law requires is if you as the landlord have already evicted a tenant or have taken assets and sold those assets in order to satisfy rental arrears, you now essentially, if you are eligible as a landlord for rent relief, have to give the tenant the unit back, allow them to take occupancy of the unit, once again, resume their operations. And if you have assets that you have not sold yet, return them to the tenant so that they can carry on business as usual. If you cannot restore the unit, and this is one thing that has a lot of landlords concerned, if you cannot restore the unit and you cannot restore the assets, then the laws require that you compensate the tenant. Pay damages is the way it's phrased in the new laws. So lots of questions around, you know, what is the scope of compensation that's required? Is it, you know, just you know, straight cost of assets that were taken and sold? Is it compensation for rent, or is it also compensation for lost business opportunity? how broad are these claims for compensation going to be? So there are lots of questions, and I'm sure there will be a lot of interesting disputes in court to try and figure that out. Going into some of the uncertainty, and again, very cursory because there are many questions that surround this. As I mentioned, the gateway criteria for these new laws is that the landlord be eligible. Now, what a lot of people are confused about is, well, if the landlord eligibility requirements as set out in the program requirements are not met, then what happens, or how does that intersect with the eligibility requirements of the tenant? The key thing to note here is that the eligibility for the landlord is synonymous with eligibility for the tenant. The landlord is not eligible unless the tenant is eligible. So they're one and the same, and there's a lot of confusion about, if my tenant is not eligible, but I am eligible as the landlord, does it apply? The question is, the answer to that is no. If your tenant is not eligible, you are not eligible for rent relief, and the ban doesn't apply. Another question that's popped up is what sort of defaults or what sort of remedies are prohibited by the landlord. So it's interesting because the legislation, the laws are quite broad. It's the ban on evictions doesn't just apply to non-payment of rent. It seems to apply to all defaults. So in other words, if there's something else in the lease that has been breached by the tenant aside from non-payment of rent, the ban would still apply. So both non-rent defaults and rent defaults seem to not be a permissible grounds for eviction during this non-enforcement period. The other thing that is interesting is, how do you essentially go about allowing your tenant to reoccupy the unit if they've vacated the unit? What are the requirements there? There's no real specific notice requirements how you go about formalizing and reinstating the lease. However, the act does state that the lease needs to be reinstated on the same terms as it was prior to the eviction. So the procedure on how you get the tenant back into the unit, not 100% clear, but it's clear that when the tenant is back in the unit, it's on the same terms as before. So that's just a couple of issues to turn your mind to. And with that, Tanya, if you wouldn't mind going to the next slide, please. So we've received a lot of questions from landlords about, how do I protect my investment? How do I protect the continued profitability of my commercial unit? And so here's just a couple of thoughts. A lot of things will be driven by the particular facts, but some things you may want to consider as a landlord. So one is, there's nothing stopping you from lining up a prospective tenant. Now, if you're certain that regardless of the ban on evictions or rent relief, that it's pretty much inevitable that your tenant will not be able to make up rental arrears and will not have a sustainable business after COVID is said and done and the economy reopens, then you should try and get ahead of that. What you do want to be conscious of is, you don't want to enter into an agreement with a prospective tenant that you can't honor, right? You never know. Your existing tenant may be able to obtain some sort of line of credit from a cosigner, repair the damage done, and essentially put their tenancy back in good standing. So you don't want to overpromise and enter into an agreement with a new tenant without covering your bases. Another solution, which is quite common, we see a lot, but you have to be careful of the terms, is entering into a rent deferral agreement. So basically postponing their rental arrears for payment in a future date. You can insert a bunch of other terms and conditions on that, have accelerated damages. Again, it's just one way to kind of set yourself up for the future to have a more expedient eviction, clear grounds for eviction if the rent can't be made up, and if you're forced to allow the tenant back into the unit for the time being. The last thing is, you may want to obtain consent to judgment. So judgment is a piece of paper awarded from the court, says, I, landlord, am entitled to X number of dollars for rental arrears, and I would like a writ of possession based on the rental arrears. So there's nothing stopping you from obtaining in structuring a rent deferral agreement or some kind of other settlement agreement, having the tenant sign consent to judgment. That way, you go into the court if there is the default that you anticipate, and there's no kind of hassles fighting over how things transpire. You already have that consent from the tenant to go in there and have things executed and done, and that will expedite your court process. So that's just a few solutions. And Tanya, I will pass it back to you.
So before we continue on to the rest of our presentation, just want to pause and answer any questions you may have about commercial tenants. So I saw that there was one where we were asked, as a tenant, what should I do if the landlord does not want to apply for the Canada Emergency Program? So my thoughts, thank you for your question. My thoughts are that you should explain to the landlord that the law has changed. And if the landlord qualifies for this program, then you are at a point where you can pay 25% of rent and not get evicted. If the landlord proceeds to try to evict you, it won't be very difficult for you to get an order from the judge or a court to get back in there and ask for part of those legal fees to be paid, because you shouldn't have had to resort to court. Jordan, is there anything you'd like to add for that one?
Yeah, so again, the question was, as a tenant, what should I do if the landlord does not want to apply? A couple of things, right? I mean, if you are, if your circumstance does make it that you are protected under the ban on evictions, then essentially you're in a position where the government is trying to force the landlord to opt into the rent relief program, right? And so if the ban does apply, you know, really it's to the landlord's benefit to obtain some rental income as opposed to none. So if the ban is applicable, you do have some leverage there. It's really going to depend on your circumstances, how good of a tenant you are historically, how long you've been there, and trying to leverage that relationship and leverage the ban on evictions to your favor to convince the landlord to opt in.
Okay, so another question, we're getting quite a few questions. One is, what if the landlord wants to lock the tenant out until a rent increase is implemented? Is that viewed as the same as eviction under the reforms? The person who asked the question, I wonder if you're speaking about commercial rent. I'm going to assume that you are. Jordan, do you want to take a stab at answering that, or would you like me to?
No, so if a tenant qualifies for the relief,
so the landlord wants to lock the tenant out until a rent increase is implemented. So, and then is that viewed the same as eviction? So my thoughts are that if a landlord wants to lock the tenant out, that would constitute an eviction because the locks are changed. The tenant can't get back in. And so that would be difficult for the landlord if the landlord qualifies under the proposed law that was implemented last week. I don't recommend that the landlord do that.
Yeah, so one thing to bear in mind here too is that the way the ban on evictions is structured, even though it's retroactive, it does indicate that the letting the tenant back into the unit is contingent on that being possible, right? So if the unit has since been flipped and a new tenant has taken occupancy of the unit, then, you know, arguably it's not really plausible at this point in time to gain re-entry to the unit. What you would look to in that circumstance is compensation in the way of damages instead. So again, it's going to be fact specific, but gives you a sense of what sort of remedies you have under the new ban.
Another question that was asked is about subtenants. As a subtenant, what can you do if the tenant is paying on time, but the subtenant is unable to pay rent? So there's not much you can do under the law. You might have to work with that subtenant in terms of maybe postponing rent payments, reduction in rent payment, but the subtenants aren't covered under the law. Another question that has been asked is if a tenant qualifies for the relief program but was evicted due to non-payment on April 1st and was replaced with a new tenant on May 1st, what happens to the original tenant under this ban, on the evictions law? So if you were evicted and then replaced, you really can't get back in. So you might be looking at damages. Jordan, is there anything you'd like to add for that one?
Yeah, no, it intersects with the previous question. Right? If it's not practical for you to gain reentry to the unit, then really you're going to be looking at damages here.
And last one we'll answer before we move on is qualifications. Kendra asked, what about the qualifications for the landlord? Jordan?
So it's a kind of a broader question, but really the qualifications for the landlord are inextricably bound to the tenant, right? So the first question, and one that's arising in these circumstances, is what if the tenant is not being forthcoming with their financials to actually prove that they themselves are eligible? You as the landlord, you know that you're eligible. I think really the key thing here for landlords is to focus on determining whether or not the tenant themselves is eligible first, rather than scrutinizing their own eligibility. Because if the tenant themselves was not eligible, then you're kind of out of the new laws about the ban.
Right. The tenant has to have a 70% drop in revenue. That's the big one. That's the big factor.
Yeah. I mean, there are a number of other requirements too about rent can only be monthly gross of 50,000. The tenant on a consolidated basis, so let's say it's a franchise with multiple units, can only have 20 million in gross revenues. So, you know, there are a number of kind of requirements, loopholes that the tenant needs to hop through in order to prove they're eligible first before this legislation would apply.
Okay, and the last question before we move on is this person stated that I'm being asked to pay additional rent, but it equals more than 25% of my overall rent. I was told that it was mandatory. My recommendation is to find out where in your lease this is mandatory, because it doesn't sound right. And the landlord should be able to point to that in the lease. So we'll continue to move on. If you have any other questions, please feel free to continue typing them and it doesn't necessarily have to do with that particular topic. We will pause for questions again after we cover the next topic. So we're moving on to part 3, answering your property law questions. So I will pull up a poll about commercial leases, but this question is quite long, so it wasn't able to fit inside the actual question part of the poll. And here, the situation is, I am a tenant, I'm not a subtenant. I took occupancy of the unit prior to the pandemic to carry out leasehold improvements. We were ready to open on March 27th, but the business was deemed a non-essential service. My landlord is seeking payment for April, May, and June. So you were ready to open, but you couldn't. And now your landlord is asking for payment for April, May, and June. So what are your options? So I'll pull up the poll. You can ask your landlord to apply for the commercial rent relief. Your evictions have been banned, so just do nothing. Don't pay, don't do anything. It depends. None of the above or unsure. Could you please vote? And I'll give it about 10 more seconds. Okay, I'm going to end the poll now. So the majority of you believe the correct answer is A, ask the landlord to apply for rent relief. Jordan, will you tell us what the correct answer is?
Yep. So next slide, please, Tanya. So the answer is actually C, it depends. And the reason why it's C has to do with the dates in that scenario. So the eligibility requirements, one of them for the rent relief program is that the business be open on or after March 1st. And you could see in that scenario that the open date was March 27th. So what this question is getting at is, first of all, was the business actually open? Now, the understanding of open as it's set out in the rent relief requirements is revenue generating. So assuming that this is the first time this business is getting off the ground, no revenue generation, no online segment to their business, they're basically starting from scratch. Then technically, if they open the doors to their unit on March 27th, they are open after March 1st. And so they are not eligible for the rent relief program, which means that them themselves as a tenant not being eligible, the landlord is also not eligible, meaning the ban doesn't apply. So you wouldn't be able to ask the landlord to opt in because it's simply wouldn't be possible for the landlord to opt into the rent relief program, and you wouldn't be able to rely on the ban because the ban requires eligibility for the program to exist. So really here, what you're looking at is a scenario where you have to assess how sustainable your business is as a tenant. And we provided a graph here. It basically shows the percentage of layoffs in sectors of the Canadian economy. These are statistics that are provided by Statistics Canada. And you can see here, one of the prominent ones is hospitality, to nobody's surprise, but it gives you an indication of what sectors of the economy are really truly being impacted by COVID and are likely to have a dramatic decrease in revenues and operations. So you have to look at your business and think, okay, post-COVID, can I actually get myself off the ground? Can I satisfy these arrears and rent? Can I carry on? And if you can't, if you don't think you can, then you may want to look to your lease and to other remedies to try and get out of the relationship while you can and minimize your losses. If you do feel that you have a sustainable business post-COVID, then you should try and work with your landlord, going back to what we suggested earlier, perhaps a rent deferral agreement, some form of an abatement. It's really going to depend on what sort of leverage you have. Next slide, please, Tanya. So here's a couple of suggestions just dealing with leases going forward. We mentioned a force majeure clause in our previous webinars. It's a paragraph in your lease that essentially deals with acts of God, as people tend to call them. You can set out one act of God if you have a force majeure clause to be a pandemic, right? So when this scenario that nobody could contemplate, that is nobody's fault, arises, here's certain rights that get triggered. And one of those rights could be, and this is just a thought, something you may want to turn your mind to, is if there's a pandemic during the leasehold improvement period, maybe your rent gets modified for that period of time. Maybe your rent gets waived entirely, right? You usually have some form of reduced rent during the leasehold improvement period. The point is, you can essentially work in your protections for if something arises during the leasehold period. Tanya, next slide, please. So here's one example of something you can consider. You can have the force majeure clause during the leasehold or after the leasehold improvement period trigger the rent being converted into a purely monthly percentage lease. So in other words, your rent is contingent on how much revenue you generate. And if you were to have a clause like this, if you were able to negotiate it and have it included in the lease, essentially you would only be responsible for providing a fixed percentage of your revenues to the landlord as in the form of rent, and your base rent could be waived, right? Generally, percentage leases, there's usually some form of base rent and then a percentage above that you pay the landlord on a monthly basis. Some other solutions, the next three ones deal essentially all with the same thing, which is building breathing room for yourself during the leasehold improvement period, right? So having inducements, right, which is essentially a monetary contribution by the landlord toward your improvements to the unit. You can also have tenant inducement, which is a form of reduced rent during the leasehold improvement period. And you can look to just have enough financing in place, right? You should never structure your financing so that it's down to the dollar, especially in your first months of operations. There's usually a lot of uncertainty, unexpected costs. You want to work with your financial advisor make sure that your lines of credit or whatever other forms of financing you have are robust enough to give you some breathing space. You never want to be down to the dollar. Tanya? And just a brief reminder, we've spoken a lot about commercial leases in our past webinars. We encourage you to look back at our previous webinars for more insight on the rent relief program and other commercial lease issues.
So are there any questions before we move on? I see one here, which is, what can I do if the landlord has locked me out of the unit because I won't pay the increased rent? In this case, the landlord does not have a legal right to increase my business rent, but is citing increased costs due to COVID-19 measures. And my answer to that is, if your landlord has locked you out, increase the rent and it's not in your lease or rental agreement, then you might have to go to court and get a court order. Courts are dealing with emergency matters, and this would be seen as an emergency, so I don't think you would have to wait. I see that someone else has your hand raised. I can unmute you if you'd like to ask the question. Last name is Solo, or you can type in your question. I just want to make sure that we get to your question. Okay, you're still on mute. Okay, I think you're still on mute. So if you have, if you can type in your question in the chat box, then we will be able to get to that question. We'll move on to the next part, which is frustration of contract. So here's a question for you. Frustration of contract, sorry, not the question. I want to actually explain what frustration of contract is before I ask the question. So frustration of contracts, a few of you wrote this in that you want us to speak about this, so we've customized this for you. And frustration of contract is when it's impossible to complete your contract. And with frustration of contract, you don't actually have a paragraph in your contract that speaks to the situation. So what it would mean is that someone would say, due to COVID-19, I can't fulfill my obligations, but there's not a specific phrase in your contract that speaks to COVID-19 or the obligations. If you had one and a phrase in your contract, then you would then go into the force majeure type of situation where you're saying there's superior force, so I want to rely on this phrase. So that's the biggest takeaway. Frustration of contract. My contract is frustrated. I can't complete it because of the situation that's going on. So going into the question now, and this is a question based on a real, like a case that occurred last year, went all the way to the Court of Appeal. And what happened here was this person agreed to purchase a home. The mortgage lending rules changed, so the price of the property dropped, and this person was unable to get a mortgage to close on the property. So my question to you is, has this contract been frustrated? So if you're unable to pay for the property because of the changes in the law, the changes in the rules or circumstances, is that frustrated? So yes, it is frustrated. You're not going to be held responsible because you can't complete it because the circumstances have changed. No, it has not been. Maybe depending on the circumstances, that what maybe really means. None of the above, or you're just unsure. So could you please vote? And I'll give it about 10 more seconds. And I'll end it now. So it looks like there's a tie. So yes, no is a number one answer. No, the contract is not frustrated. That's what the majority of you said. And then there's a tie, maybe depending on the circumstances. Yes, it could be frustrated. but the majority of you said no. So moving on, the answer is B. The majority of you got the right answer. In that situation where went all the way to the Court of Appeal, where the person said, it is frustrated, so I'm not responsible. Don't keep my deposit. Don't sue me for damages. I'm not responsible. The Court of Appeal disagreed and said it's not frustrated. The property was able to be given to that person. The person was just not able to finance it. So keeping that in mind, how do you get around that situation? So if you're in that situation now, you may want to, the buyer wants to purchase, the seller wants to sell, you may have to renegotiate the agreement of purchase and sale, maybe a reduction in price, a vendor take back mortgage, any of those type of things to get it to close. Knowing what you know now, in the future, you might want to have a volatility of risk type of paragraph. And what it means is in a situation, and it's highlighted in red, the key words, if you have this in your agreement of purchase and sale and the purchaser is unable to get the financing, then the purchaser has the right to cancel the contract and get the deposit back. So if the value of the property is reduced by 15%, you can tie it to inflation, anything you really want, but it really gets the purchaser out without losing the purchaser's deposit or being sued for the difference in price of the property. So keeping in mind force majeure phrases, we covered that extensively on April 27th. If you go back to that, at the 16th minute is when we started to speak about that. But force majeure phrases are phrases where you can say, due to the act of God, I'll get out of my contract. Make sure it's customized and make sure because if you have it in there, it doesn't necessarily mean that it would apply to your situation. So make sure that it's properly customized. Any questions before we move on? I see a question here where there's an example that was just provided of house prices falling due to the government measures. What about house prices falling due to COVID-19 measures? Would that be frustration, or would we need a specific clause like force majeure? So the case that I mentioned was about how government measures. Would it apply to COVID-19? I believe that falling house prices will depend, regardless of the circumstance, would never be a reason to say there's frustration. If you want to rely on reduced value of a house to get out of a purchase, you need to have some kind of paragraph or force majeure paragraph. So moving on is I'm going to power of sales. And so before I ask the question about power of sales, I just want to explain what it is. So a power of sale is when the lender, mortgagee, such as the bank, is not receiving payment for the loan, the mortgage. And so there's about 3 months of default usually, where the lender says to a court or a judge, I want possession of this property because I want to sell it because my loan is not being repaid. And the document that enables that lender to give it to the sheriff or the enforcement office is called a writ of possession. But you need a judge to give you a writ of possession. It's really strict because the remedy is quite extreme, like a person has to vacate their property in order to give it back to the lender so that it could be sold. If the person pays the loan and puts it into good standing, then there will not be an order made for a writ of possession. So, but that's what a power of sale is. And so we've also been asked what's the difference between this and a foreclosure. Power of sale is when you sell the property, whatever profit is made goes back to the person who borrowed the money or the people. A foreclosure is when you get to keep the property, keep the profits. So moving on to the question, keeping in mind what a power of sale is do you believe that a mortgage lender will be able to sell property under power of sale during COVID-19? So can a mortgage lender, the bank, sell property under power of sale now? So your possible answers are yes, a mortgage lender can, no, a mortgage lender cannot, none of the above, or I'm not sure. Could you please vote? And I'll give it about 5 more seconds. And I will end it now. So the majority of you believe that a mortgage lender can sell property under power of sale during COVID-19. Some of you are unsure, and some of you believe no. So the correct answer here is A. So the majority of you got it. And keep in mind that the courts have stopped ordering writs of possession, but mortgagees are free to sell the property they obtained possession of prior to the pandemic. Now, there was an interesting case that was recently decided called MCC Mortgage Holdings, Inc. And what happened here was the lender possessed the property and received a writ of possession before the COVID-19 happened. And after COVID-19 happened, the person who was in default of the loan broke into the property and said, you can't kick me out because the court's not ordering writs of possession. They're not going to order me to leave. And the court said, in this situation, nothing is absolute. And in this situation, we are going to order you to leave because the lender possessed the property before this happened legitimately, and you broke into it, and we're not going to reward you for doing that. So you have to go. So some tips is lenders selling the property should be cautious of the price. If it's a power of sale, prices of property may have reduced, and if you sell the property for far less than the market value, that the borrower may say there was an improvident sale, so you have to be very careful. And no one, borrowers or lenders, cannot take advantage of this suspension. Are there any questions before we move on? So I see one question is, mortgage lender sold house under power of sale and got possession in January. The price they sold it for is really low. When there was a complaint, it said it was just because of the pandemic. What can you do? So this is a gray area. You have to provide some evidence of what the market value should be. And if it is much lower than what market value is, then you can say that the sale wasn't carried out properly and that you are owed funds. So going into I believe it's our last poll, residential construction. I'll read out the scenario to you before I launch it. Pretend in this situation you're a contractor and the client has approved a number of extras during site visits, but is now saying the contractor did the work without any approval. The client only wants to pay the original estimate work, although the extras and unforeseen expenses have exceeded the price by roughly 12%, and there's no written approval of the extras. So the contractor is owed extra money, but there's no it's not written down anywhere, text message or anything about the extras. I see Cora, you've raised your hands. Please feel free to type in your question, and we'll take a look at it when people are answering this poll. So the contractor's best option is to put a lien on the property, do not charge for extras and move on, none of the above, or unsure. So what should the contractor do in a situation where it's owed an extra 12% and there's nothing in writing? Put a lien on the property, do not charge for the extras and move on, none of the above, or you're just not sure. Could you please vote? And I'll give it about 5 more seconds. So the contractor's best option is to put a lien on the property. That's what the majority of you said. And Jordan will let you know what the correct answer is.
If you wouldn't mind just Perfect. Thank you. So the majority of you are correct. The answer for the contractor would be to put a lien on the property. And that's because a lien, which is a piece of paper that essentially says, I'm a contractor, I supplied X dollars of labor and materials to you, and I'm owed for what I supplied to you. That document gets registered on title. A lien is for anything that has actually been supplied. So regardless of whether or not the extras were put in pen and paper form, if they were supplied to the property, the contractor can lien for that. What is interesting about this scenario, the reason why we put it in, is that it's hinting to consumer protection law. Residential construction, depending on the circumstances, assuming the person who's buying and renovating the home isn't generating a business income from that by flipping properties, is likely to be considered a consumer under the Consumer Protection Act, which specifies that a construction project, that the estimated cost cannot exceed, the actual cost cannot exceed the estimated cost by more than 10%. So what this situation is hinting at is, let's say, for instance, the extras in this scenario only cost 1%. Then you have 1% above in unforeseen costs. So you have that additional 11% in unforeseen costs. 1% would have tipped above that 10% threshold. So in theory, the contractor would have to waive that 1%. So this is a very important thing to keep in mind, both as a contractor and as a homeowner, to make sure that you're not running afoul of the consumer protection laws. Next slide, please, Tanya. So we've set up a number of solutions here, or suggested solutions for contractors to contemplate. It's very tight times economically, and there's a lot of uncertainty. And so chances are, if people are entering into home renovation contracts, they're going to want to have more certainty, right? You may see as a contractor more requests for a flat fee guaranteed price. If that is the case, you have to build in a premium to cover yourself on overhead expenses to make sure you're fully covered. If you are in a situation where you do have to lien the property, you are within your rights, you've charged things justly as a contractor, then you may want to consider having in your contract a clause that allows you to recover your lien registration fees. It does cost quite a bit of money to register a lien, and so you want to essentially cover your bases so you're not out of pocket. The other thing, and this actually, although it benefits the contractor, it also benefits the homeowner and the relationship as a whole, is to have a clear change work order system. So make sure that nothing is done on a handshake. If something in the scope of work is changing, have a change work order, right? If the contractor, you open the wall as a contractor and you discover that, hey, what would have taken 2 hours is now going to take 20 hours, explain why in a change work order, explain why that changes your costs on the project. That benefits you as a contractor because you're not going to have to deal with inadvertently running into the consumer protection laws. And it also benefits the homeowner because there's full transparency and they understand exactly what's going on. And the last thing is, if as a contractor you want to stick to the estimated value as opposed to a fixed contract price, you need to have clear disclaimers, right? And you should be, again, transparent with the homeowner because it benefits you as a contractor, it gives you more credibility, and it avoids unnecessary disputes, right? It avoids a situation where you have to lien the property, which should be a last resort. Tanya?
So before concluding, I just want to let you know that you'll receive a newsletter after this webinar. It will contain a copy of this webinar, so it takes some time to upload, so give it an hour or so. And if you fill out the survey, we will provide to you a Starbucks card or a Walker Law face mask. We also want to say thank you to our friends for promoting this webinar to their friends, members of their organizations, or their contacts. Really, really appreciate it. Thank you. And also, if you have any old technology laying around your home that you're not using, please consider donating it. We will wipe it clean before we hand it in. But renewed computer technology is really trying to gather old equipment so that children can continue to learn throughout the summer. So before I conclude, we have about 5 minutes here. Do we have any questions? So I see that there's one here, and I'll stop the share. So when equalizing the marital home, there's no mortgage clear title. The date of separation is January 1st. The value of the home is $800,000, but the sale of the home is $100,000 less. What does the spouse receive? So generally, you're required to receive a share of the profits of marriage, not the value on a certain date. My knowledge is kind of limited because I'm not a family lawyer, but that's my understanding. Before we conclude or wrap it up for today, are there any other questions?
I got a question about whether or not the ban is a forgiveness of your obligations under the lease. Mm-hmm. And the answer to that is no. It's considered to be just a deferral of your obligation. So when the ban ends right now, it's slated to end on September 1st. Interestingly, the door is open for that time period to be extended. So we'll have to watch that and monitor that. But it's considered just a deferral. So if your arrears in rent are still in effect as of September 1st, the landlord can go in and still, repossess the unit on that basis. And they can even take an enforcement action ahead of time to line themselves up so that they can take possession as soon as the ban is lifted. Because the writ of possession can be obtained, it just can't be effective during the non-enforcement period.
Yes, yes. Okay, so are there any other questions? I see one here. My client was in an accident and died suddenly. Their estate does not want to proceed with the transaction. So this is, I believe, a real estate agent. The seller is upset because the market has crashed and now they're going to lose $50,000. If they sue, will the estate win? So I believe there was a transaction entered into. It's supposed to close. Someone passed away, and should it close? My thoughts are that the estate might be held responsible because there is a contract to close, and it should. And any debts or anything of that nature can be dealt with by the estate. So I hope that answers your question. I see another question from David. Can a construction contractor delay work and claim it is because of the pandemic, even if construction is allowed? I could answer that, but Jordan, this is right up your alley. Do you want to answer?
That's a really interesting question.
Thank you, David, for your question.
Yeah, it's really going to depend on the facts. So say, for instance, there was a specialized material that was being ordered across the border, and due to the pandemic, the shipping of that material is just not possible, right? It's going to be delayed potentially indefinitely, or maybe it's off the block and you have to find alternate materials, right? If there's kind of key materials that can't be obtained, for instance, just one example, then, that is kind of outside of their control, right? Something that arose through the pandemic, and we have seen those scenarios. However, if it's just due to the fact that they are not willing to implement the health and safety guidelines that the government has instituted in a way to get the project off the ground again and get it moving, then yeah, potentially there could be some liability on the landlord, or sorry, the contractor. But again, it's really going to depend on the circumstances.
Yes, I mean, I agree. I have nothing else to add on that one. Thank you for your question. So we are going to wrap it up now, unless there are any other questions. We only have about a minute remaining. Just want to thank you all for joining us today. Thank you for your time. If you have any more questions, please feel free to reach out to Jordan or myself. Thank you, Rishi, for your hard work. I hope that you all stay safe and healthy during this pandemic, and especially now we're in stage 2 and dealing with more people. You continue to stay safe. Thanks so much. I see in the chat. Oh, Nagy, you're welcome. Thank you. Thank you for joining us. Bye, everyone, and I hope you have a great day. Bye. Thank you, Jordan.
Thank you.